show, Stephen will be presenting our AIR requirements. This is the sunsetting of HVCC. There's no reason to say HVCC. It doesn't exist anymore. It hasn't for a long time. That's why we're seeing a lot of changes in forms, policies, and whatnot from our investors. And we have to make sure everybody in our company is compliant with these matters as well. Just make sure we don't have any technical difficulties. Could someone just in the chat window say, hey, yeah, Mike, I can hear you. All is good?
Maybe check the questions as well.
Anybody?
Oh, we can hear you.
Okay,
all right, thank you. So, tentative, I mean, it is legal. This is law now. So Stephen is the expert on this. So please pay attention. We are requiring all new employees to sign an acknowledgement that they've read this book, and everybody in the company now that they've been through the training and or watched the broadcast and sign the acknowledgement that they will live and prosper by the AIR requirements. So with that, Stephen, the time is yours.
Great. Good morning and good afternoon to everyone. We'll try to go through this as quickly as possible. We know that appraiser independence requirements is not exactly a exciting subject with the multitude of uses between the Dodd-Frank Act, the Wall Street Reform and Consumer Protection Act, Regulation Z, Fannie and Freddie's adoption of it, and FHA's adoption of their own appraiser independence requirements. There is a lot of duplication and a lot of nuances between the different sections. So we'll try to, hit the bullet points that's going to be most applicable to you, and try to get through this as quickly as possible so that we can get back and producing loans. So with that, talk about the Dodd-Frank Act and HVCC.
Stephen, do you have mouse access? Okay, it looks like you do.
I do.
Next.
All right. Section 1472, Title 14, which is referred to as the Mortgage Reform and Anti-Predatory Lending Act, is a section of the Dodd-Frank Wall Street Reform and Consumer Protection Act. And this act called for the sunset of the Home Valuation Code of Conduct, which we refer to as the HVCC. Section 1472 itself is titled the Appraiser Independence Requirements, and it codifies these requirements into Section 2 of the Truth in Lending Act, TILA. Some major differences between HVCC and Appraiser Independence Requirements. HVCC was developed as an agreement between Fannie Mae, Freddie Mac, the New York Attorney General Andrew Cuomo, and the Office of Federal Housing Enterprise Oversight. It was never a law or regulation. It was just an agreement between those four parties. And the difference between HVCC and AIR on that respect is AIR is part of the amended TILA and is therefore federal law. Other difference, HVCC never applied to FHA mortgages. However, AIR applies to all mortgages that are subject to that section of the Truth in Lending Act. And if you would like, you can actually read the AIR language at the website below on the screen. Summary of the Truth in Lending Act, Section 129E. We're just going to go through key points here. ICER Residential Lending, LLC, shall comply with the Truth in Lending Act provisions governing appraisal independence as established by the Dodd-Frank Wall Street Reform and Consumer Protection Act. In order to maintain the appraiser independence, TILA prohibits the following actions in basically any type of our transactions, but specifically for consumer's principal dwelling, and that's causing or attempting to cause value assigned to the property to be based on a factor other than the independent judgment of the appraiser, mischaracterizing or suborning any mischaracterization of the appraised value of the property securing the extension of credit. A couple more prohibitions from appraiser independence requirements, is seeking to influence an appraiser or otherwise encourage a targeted value in order to facilitate the making or pricing of the transaction. And last prohibition of this section is withholding or threatening to withhold timely payment for an appraisal report or for appraisal services rendered when the appraisal report or services are provided for in accordance with the contract between the parties. There are certain permissions that are allowed specifically from this section, and we may engage in the following permissible conduct, and that's asking an appraiser to consider additional appropriate information on the property, including information regarding additional comps to make or support an appraisal, asking an appraiser to provide further details, substantiation, or explanation for the value conclusion, or simply asking an appraiser to correct errors in the report. Now, some of this language should sound familiar because it is virtually word for word from the HVCC, specifically the requirements that a lender cannot withhold or threaten to withhold payment, and additionally the statement that a lender may ask for an appraiser to explain or substantiate an appraisal to correct factual errors. Now, Regulation Z goes into a little more detail compared to the Dodd-Frank Act, and this is where we're going to get our definitions of what's covered, who's covered, and why. And the covered persons is Regulation Z, valuation independence, applies to creditors, appraisal management companies, appraisers, brokers, realtors, title insurers, and any other settlement service provider as defined in RESPA. Covered transactions. Both open and closed-end credit transactions secured by a consumer's principal dwelling are subject to the valuation independence rules. And just as a quick note, the GSCs still require valuation independence for second homes and non-owner occupied properties. So just because Reg Z specifically states consumer principal dwelling, the GSCs are still going to require that for basically all of their loans. And what is a valuation? Valuation is any estimate or value in written or electronic form other than one produced by an automated model or system. So AVMs aren't really considered the valuation for these purposes. Some more definitions. Valuation management functions. These are administrative functions performed in connection with valuations, including, most importantly, recruiting, selecting, or retaining a person to prepare a valuation. Reg Z also has their own prohibited acts and practices. It provides a little more detail in the prohibited acts compared to the Frank-Dodd Act wording, but it's basically the same part for most sections. You can't intimidate, you can't bribe, you can't collude, you can't not coerce. But based on this, we have our policy: we will not engage in the following acts: seeking to influence a report for a minimum or maximum value, withholding or threatening to withhold timely payment to a person because this person does not value the consumer's principal dwelling at or above a certain amount. So we can't take away an appraiser's pay just because they do not reach our threshold value, implying that current or future retention of the person depends on the amount at which the person estimates the value of the consumer's principal dwelling, excluding a person from consideration for future engagements because the person reports a value for the consumer principal dwelling that does not meet or exceed a predetermined threshold, or conditioning the compensation paid to a person on consummation of the covered transaction. So we can't base an appraisal to be paid for based on the fact that the loan is going to close. Additionally, we cannot falsify or materially alter a valuation or induce any person to violate the prohibition against falsifying or materially altering a valuation. And an example here is loan officer may not coerce a loan underwriter to alter an appraisal report to increase the value assigned. We also cannot engage in indirect acts or practices with respect to prohibited conduct. And an example is creditor attempts to cause the value of an appraiser engaged by an appraisal management company assigned to the consumer's principal dwelling to be based on a factor other than the appraiser's independent judgment. By threatening to withhold future business from a company rather than the appraiser himself affiliated with the appraisal management company unless the appraiser assigns a particular value. See, even though we're not directly coercing the appraiser in this regard, it's still an indirect act of a prohibited act. What is permissible under Regulation Z? We may engage in the following acts or practices. First being, we can ask a person who prepares a valuation to consider additional appropriate property information, including information about comparable properties, to make a support evaluation. We can also request a person that prepares a valuation to provide further detail, substantiation, or explanation for the person's conclusion about the value. We can also ask a person that prepares a valuation to correct errors in the valuation. And we can obtain multiple valuations for the consumer's principal dwelling to select the most reliable valuation. We can also withhold compensation due to breach of contract or substandard performance of services. And we can take any action permitted or required by applicable federal or state statute, regulation, or agency guidance. Reg Z also has a section on the prohibitions on extensions of credit. And if ICER knows that prohibited conduct was engaged in or that a conflict of interest exists in connection with the valuation, at or before consummation, we shall exercise reasonable diligence to determine whether the valuation materially misstates or misrepresents the value of the consumer's principal dwelling before extending credit based on the valuation. And if we determine that that valuation materially misstates or misrepresents the value, no credit will be extended based on that valuation. Reg Z also, looks like we went back a page. Reg Z also has a section on customary and reasonable compensation, and policy is that we will compensate a fee appraiser for performing appraisal services at a rate that is customary and reasonable for comparable appraisal services. And the following factors will be used in determining an amount that is reasonably related to recent rates paid for comparable appraisal services performed in the geographic market of the property. And that includes type of property, scope of work, time in which appraisal services are required to be performed, so rush fees, fee appraiser qualifications, appraiser experience and professional record, and their work quality. As such, we also have to make sure that we refrain from the following anti-competitive acts, and that includes entering into any contracts or conspiring to restrain trade through methods such as price fixing or market allocation, and engaging in acts of monopolization, which isn't really an issue for us. And we can be presumed to comply with these requirements through a couple means. by relying on information about rates based on objective third-party information, including fee schedules prepared by independent third parties, such as government agencies. So looking at the VA appraiser fee schedule is one way. And if we rely on information based on fee schedules, studies, or surveys, compensation paid to fee appraisers for appraisals ordered by appraisal management companies is excluded. So we can exclude the appraisal management company fees from this valuation of comparable and reasonable compensation. Reg Z also has a section on mandatory reporting, and if we find that an appraiser has materially failed to comply with the USPAP or ethical or professional requirements for appraisers, the matter will be referred to the appropriate state appraiser certifying and licensing agency within a reasonable period of time. And the following acts or practices are material failures to comply, and this list is not exclusive. So if it's not specifically on this list, it doesn't mean it's not necessarily something we can be reporting. And mischaracterizing the value of the consumer's principal dwelling, performing an assignment in a grossly negligent manner, accepting an appraisal assignment on the condition that the appraiser will report a value equal to or greater than the purchase price for the consumer's principal dwelling. The selection of appraisers or persons who perform evaluations. ISERV will select, evaluate, and monitor the performance of appraisers and persons who perform evaluations in order to ensure a qualified, competent, and independent person complete the appraisal or evaluation. And the person at ISERV who selects or oversees the selection of appraisers, persons providing evaluations shall be independent from the loan production area. And lastly, use of a borrower-ordered or borrower-provided appraisal violates the agency's regulations. So we cannot accept borrower-ordered or borrower-provided appraisal as part of Reg Z. And if a subsequent appraisal is required, if we find it's necessary, we will select the most credible appraisal or evaluation rather than the appraisal or evaluation stating the highest value for the subject property. And now that we've gone through the Dodd-Frank Act and the amended Reg Z requirements, we'll just touch upon GSE and FHA additional requirements that aren't specific in these regulations. For the Fannie Mae and Freddie Mac, selection of an appraiser, we will not accept an appraisal completed by an appraiser selected by any other third party, including mortgage brokers and real estate agents. That's straight from Fannie and Freddie. And ISERV, residential lending, will not allow any members of its sales or mortgage production staff to be involved in selecting, retaining, recommending, or influencing the selection of any appraiser or for inclusion on a list of approved appraisers. And we'll touch upon that in a little bit, what significance that has. GSE requirements for provision of appraisal to borrower. It's required that the borrower is provided a copy of any appraisal report regarding the subject property upon the completion of the report and no less than 3 business days prior to closing. And in this respect, closing refers to the date the borrower signs the note. So it has to be 3 business days prior to the borrower signing the note. Appraiser independent safeguards, and these are not all of the listed items in our manual, but just some key points. And no employee, director, officer, agent of ISERV, or any other third party acting as a joint venture partner, independent contractor, appraisal company, AMC, or partner on behalf of us shall influence or attempt to influence the development, reporting, result, or review of an appraisal through coercion, extortion, collusion, compensation, inducement, intimidation, bribery, or any other manner including but not limited to. First one is requesting that an appraiser provide an estimated, predetermined, or desired valuation in an appraisal report prior to the completion of the appraisal. So we can ask for a appraiser's estimate of the value before they actually complete the report. We also cannot remove an appraiser from a list of qualified appraisers or adding an appraiser to an exclusionary list of disapproved appraisers in connection with the influencing or attempting to influence an appraisal as described in the paragraph above. And this prohibition does not preclude the management of appraiser lists for bona fide administrative or quality control reasons based on written policy. So we can't remove someone because they didn't get us the value, but we can look at the other policies and see if we can remove for something such as breach of contract. But everything's going to have to be documented. Appraiser engagement. The main point is we will not accept any appraisal report completed by an appraiser selected, retained, or compensated in any manner by any other third party. And an employee of iServe Residential Lending in a sales or mortgage production function shall have no involvement in the operation of the appraisal function. So every appraisal order is going to go through an independent person, not related to sales or production. Appraiser engagement continued. Certain parties are going to be prohibited from selecting, retaining, recommending, or influencing the selection of any appraiser for a particular appraisal assignment or for inclusion on a list or panel of appraisers approved or forbidden to perform appraisals for iServe. And other parties are prohibited from having any substantive communications with an appraiser or appraisal management company relating to or having an impact on valuation, including ordering or managing appraisal assignment. And even though it says certain parties, we actually have a definition for these parties, and that's all members of iServe Residential Lending's mortgage production staff, any person who is compensated on a commission basis upon the successful completion of a mortgage, and any person whose immediate supervisor is not independent of the mortgage production staff and process. So Fannie Freddie really wanted specifics on who is independent from production and sales when it comes to ordering an appraisal. Fannie and Freddie also have requirements for post-closing quality control review of appraisals and appraisers. And most biggest key point out of this is that we are going to re-verify the appraisal or property inspection for 10% of the mortgage loans selected for QC review by ordering a review appraisal, additional appraisal reports, property inspection report, or other appropriate documentation to check the work of the original appraiser. And compliance with the Fannie and Freddie valuation independence requirements is this policy right here. And iServe has adopted the foregoing written policies and procedures implementing its appraiser independence requirements to comply with Fannie Mae and Freddie Mac. Compliance shall include, but not limited to, adequate training and disciplinary rules on appraiser independence, including the principles detailed in the manual. Additionally, iServe must ensure that any third parties, such as appraisal management companies or correspondent lenders, used in conjunction with the sale and delivery of a mortgage to Fannie Mae or Freddie Mac are also in compliance with these appraiser independence requirements. And FHA has their own additional requirements to appraiser independence, and a lot of it's a rehash of the same sections, worded slightly differently, but we're just going to go over the key points of the differences. First is the appraisal assignment to ensure appraiser competency. specific section from FHA, and we must select an appropriate appraiser for every assignment, one who has knowledge of the market area or geographic competency. Even though that's not specific in any other policy, it is specific to FHA. We're going to use that policy for any appraiser we select, but FHA has the additional requirement that that appraiser must have specific knowledge of that market area. Additionally, FHA requires that iServe ensures that the FHA roster appraiser selected to perform an appraisal is listed as active on the FHA appraiser roster at the time of selection. If we do not have an FHA appraiser selected who is active on the roster at the time of selection, then that loan is not going to be able to be insured with that valuation. FHA preventing improper influences on appraiser is basically a rehash on who can speak with appraisers. It's worded a little differently, but it's the same basic principle. Who may not order the appraisal? Well, FHA prohibits lenders from accepting appraisal reports completed by an appraiser selected, retained, or compensated in any manner by a real estate agent, which we have seen before. But to ensure appraiser independence, FHA-approved lenders are also prohibited from accepting appraisals prepared by FHA roster appraisers who are selected, retained, or compensated in any manner by a third-party sponsored originator, or any member of a lender's staff who is compensated on a commission basis tied to the successful completion of the loan. Appraiser independent safeguards. And here's just some key points. iServe and third parties working on behalf of iServe are prohibited from the following: requesting that an appraiser provide an estimated predetermined or desired valuation in an appraisal report prior to the completion of that report. Same basic requirement as Fannie Mae and Freddie Mac. We're also prohibited from providing to the appraiser an anticipated, estimated, encouraged, or desired value for a subject property or a proposed or targeted amount to be loaned to the borrower, except, big exception, that a copy of the sales contract for purchase must be provided. And here's probably the biggest key point here is we are prohibited from allowing the removal of an appraiser from a list of qualified appraisers or the addition of an appraiser to an exclusionary list of qualified appraisers used by any entity without prompt written notice to such appraiser. And this notice shall include written evidence of the appraiser's illegal conduct, violation of the Uniform Standards of Professional Appraisal Practice standards, violation of state licensing standards, or improper or unprofessional behavior or other substantive reason for removal. So breach of contract can still be in place here, but FHA specifically requires written evidence of this conduct to be removed, and that's a key point here. Additional requirements for FHA, the appraiser selection and FHA connection. FHA actually included this section for its appraiser independence requirements, and that is the part that lenders are responsible for ensuring that the appraiser who actually conducted the appraisal is correctly identified in FHA connection. We acknowledge that HUD's ruling that lenders who fail to ensure that FHA connection reflects a correct name will be subject to administrative sanctions. So we have to make sure when we submit the loan for insuring that FHA connection is absolutely correct with the correct appraiser. We can't go back after we send it off for insuring and try to correct it that way, because we will be subject to sanctions. And they also have a specific section on who's responsible for the appraisal report, and FHA specifically states that the DE underwriter is responsible, and we shall comply with HUD's directive, which states the DE underwriter, who is responsible for the quality of the appraisal report, is allowed to communicate with the appraiser. And that's different from the other production staff. issues with communication from the GSEs, and the underwriter may additionally request clarifications and discuss components of the appraisal that influence its quality. And under this policy, the underwriter bears the primary responsibility for determining the eligibility of a property for FHA insurance. So FHA puts that responsibility directly on the DE underwriter, unlike the other entities that do not give a specific on who is ultimately responsible for the appraiser's quality. Just some final thoughts. Biggest difference between HVCC and AIR is that AIR amends the Truth in Lending Act, and that makes it federal law. We cannot diverge from that at all. ISER will not accept appraiser recommendations from any sales or production staff member for our panel. So that means we cannot take any recommendation for a new area we're entering into business. We cannot take appraiser recommendations from our branches directly, or loan officers, or any person in the sales or production area. And we'll show you a component that we have to help us obtain new appraisers for market areas in a few minutes here. Additionally, ISER will only have one approved appraiser list, but the appraiser selection will still be based on geographic location of the subject property. So it's one company list, and it will be broken down according to serviceable areas by the appraisers. So that way we will still meet the requirements for FHA, Fannie Mae, Reg Z, but we will only have one list of approved appraisers. It won't be based on anything other than company-wide approval. And the removal of any appraiser from our panel must be in compliance with our AIR policy. And that's not just the AIR policy we went over with the key points today in the PowerPoint. It means the entire AIR policy manual that is going to be published to the intranet and was sent out this morning. So that includes making sure we have written evidence of why they're being removed. If it's an actual issue with mischaracterization or just gross negligence, we're going to report them to the correct authorities. So anything that has to do with the removal of an appraiser, we're going to have to keep written records of. And that includes miscommunications or lack of communication, because that can be a basis for removal. It's breach of contract. It's also poor business practices on their part. And we can use that as a reason, but we have to have written documentation for removing the appraiser. So that's just something to keep in mind. And I know we're going to show you a section of the for appraisers, but we'll also be taking questions in the question section below. And with that, I'm going to hand it back over to the rest of the Vapor team.
The rest of the Vapor. All right, actually, Stephen, I have a couple of questions that I wanted to see if you could to clarify. The removal of appraisers from our panel, can one of those deciding factors be investor exclusionary list?
Yes, that is going to be specifically listed on the website of any professional removal, disbarment, anything to that effect. That's going to be a consideration for removing them from our list. And that's written evidence right there, because we'll have the list from our investors, and we can show that to them when we actually send the written notice of removal.
Okay. And then does AIR have any bearing on the transfer of an FHA appraisal into us, for example?
Any specifics, like it does, because any appraisal has to be ordered compliant with the Reg Z requirements and also the FHA additional guidelines. So it still has to meet those requirements, but is there a specific question that you're looking for?
So if we, for example, had an FHA appraisal transferred into us from another lender, and it has an AIR compliance cert, are we okay to accept that appraisal? Because I mean, HUD only have one appraisal of note unless there's something materially defective with that appraisal.
Right. We can be. We have to make sure that that appraisal was not ordered by a, what was the exact words from HUD on that?
Right, to make sure it's totally compliant
Yeah,
with their policy.
Yeah.
Right, but it cannot be from any third-party sponsored originator. So it can be air compliant, but if it's coming from a third-party sponsored originator, we can't accept it.
Yeah, it would have to be from DE lender to DE lender.
Exactly.
Okay. We have a few questions up on the board here that I will read out to you. In reference to must-have knowledge of market area, quote unquote, is there a mile radius? We have some appraisers who cover several counties.
No, there's no specific requirement as to mileage of what's required for the geographic area that they are familiar with. It's just going to be looking at their experience, their time in that market, their access to data systems for that specific market. I know in some counties it's broken out, or some states it's broken out by counties, others it's other different types of regions, so it depends on that appraiser's specific experience. It's not going to be based on 60-mile radius from borrower's home or from appraiser's home office. There's no guidelines for that specifically.
Next question, is the FHA appraiser roster located on the FHA website? I can take that one. Yes, it is. If you're within FHA Connection, you will go to your approval list, and you will be able to look up appraisers. And we can send you out a link for that if you need it as well. Next question, can a processor communicate underwriter conditions on an appraisal already received and reviewed by the underwriter with the appraiser?
I believe that is yes. It's actually, we run into that a lot. Our branches want Stephanie to have corrections made or track down things on an appraisal already performed. And actually the processors have that ability. Stephen, correct me if I'm wrong legally, but my understanding is that that is just fine.
Yes, we can communicate that type of information to the appraisers.
Stephen, this is Alan. Can I ask a quick question?
Sure.
Quick. One, let's say I'm at the Napa office and an appraiser wants to become approved in my market, or I know of an appraiser that wants to become approved in my market. There's no problem in my referring that appraiser to our website to become approved, correct?
That is correct, because at that point we're not soliciting it from the branch manager. We're not knowing who's actually sending us this referral, and therefore the branch manager is having no actual influence on us selecting that appraiser for our panel. The appraiser is still going to independently have to meet our own guidelines and qualifications.
Absolutely perfect. Now, let's say, assuming also I'm at the Napa branch, only appraisers in that Napa market will be selected. Or if I'm in the Pleasanton branch, it won't be a situation where we'll be going using Pleasanton appraisers for Napa property. We'll be able to figure that out at the corporate level, correct?
Well, if the appraiser is familiar with both areas, because those aren't exactly geographically very distinct areas, then no, they would be eligible for any geographic area that they are approved for.
Okay, well, they are geographically distinct. So I'm assuming that in the approval process we would have that information available?
We would have the information of what areas they service.
Okay,
Right.
perfect.
Okay. Service. Next, up on the screen right now, everybody should see the page of our website, and we will send out a link. We're actually...
It's under the Join iServe. There's a link now that actually says become an appraiser from our main corporate website. This is information that an appraiser would be required to fill out to request to be added to our panel.
And you will see here that they have the ability to upload their resume, their license, their E&O, and then also a list of the counties that they cover. So we will have that information on our list.
Alan, to speak to your question more, the new software that we're rolling out, LenderX, that a couple branches are piloting on right now, takes into account the distance from the subject property to the office of the appraiser when it chooses them. And so they're prioritized by several things, one of which is distance. The only time, and I think it'll be rare, is when, let's say, the guys down in Pleasanton are doing a loan and it happens to fall right next door to an appraiser office that maybe used to be Napa's. In that case, they may end up getting assigned that order, but we're hoping that that is the exception and not the rule.
Yeah, and my only concern there, and that's perfect. I think that takes care of it. You know, we have appraisers in Sacramento. You know, we hear these horror stories that claim that they're experienced throughout Northern California, and some of these companies will select that Sacramento appraiser to do an appraisal, you know, 100 miles away. So it sounds like we're really drilling down into a little bit more detail to make sure that that appraiser is really qualified for the particular area.
Oh yeah, we want to keep them as close as possible. An investor will look at that and say, why is this guy being chosen when he's 100 miles away? And that makes it that much harder on us to sell the loan.
Okay, perfect. Thank you.
All right, we have a couple of more questions here. Who provides the written notice to the appraiser regarding their removal from our panel?
That's a good question.
The compliance department, if they are removed, we're going to have any documentation, and like I mentioned, inability to communicate. That documentation would have to be sent to us for review, and if we determine that it really meets or it's outside, you know, the standards of professionalism, then we would send a written notice to the appraiser themselves. It's not going to come from the branch. It cannot come from the branch at all. It cannot come from processors, anyone, underwriters, no one on the production staff. It has to come from persons within the safeguards of the independence requirements for appraisers. So,
Stephen A. Martin, attorney at law. Okay, and finally, can you touch upon the value appeal policy and process?
value appeal and process.
Yeah, let's say the value comes in and
They want to do a rebuttal.
Yeah, she's saying, hey, this is crazy, way off what we estimated. How do we appeal that?
Well, we can ask for certain documentation from the appraiser themselves to support their comps and support the valuation they used. We can supply, additional information to them as well. But as far as specifics about the appealing a review, Reg Z and the GSEs have really limited us to what is allowed for subsequent appraisals. So if it comes to the point that we can't work with the appraiser to try and determine, or we disagree with the appraiser's recommendation, and it's not just, obviously you want to get the sales done if it's, people separate from production or sales review the appraiser, determine that, yes, this does not meet, USPAP standards or does not meet GSE standards, then we can look into the ordering of subsequent appraisal. But that's very limited according to Reg Z and just AIR requirements in general. Subsequent appraisals are severely limited.
Okay, maybe I'm catching a point that she's leaning more towards is what is the procedure? Catalina obviously would not go directly to the appraiser. She would have to come to our internal staff and pose a complaint, I would assume, through the appraisal department or through the underwriter, and then we would have to take it from there.
Right.
Okay.
That would go through the appraisal desk.
Probably.
Right,
and
exactly.
And actually, the processors do have the ability with the new software to send messages to the appraiser, but they have to be cleared by Stephanie first to make sure that they are in compliance. So that helps keep us compliant there.
And are we correct that it would be good due diligence if we are going to make such a claim or rebut the value in any way that we should have substantiation for our rebuttal?
Oh yeah, it has to be, because it's limitations on the amount of what can be communicated to the appraiser, even from the independent person standpoint. So it has to be very specific. It has to be through the information. We can't say we're looking for this value or we think your value is complete crap. We have to say this is, your appraisal is not touching upon these points, this information. Your comps are, this old. Why are you not considering these comps? Why are you not considering this information? And then we would get the rebuttal from the appraiser that way. We can't say we disagree with your evaluation. We are looking for them to support their evaluation. There's a better way of coming across that way.
Okay, we've got a question from Amanda and Joan. Do underwriting condition requests need to go through Lender X, or can we still use standard email? That's a very good question, and I probably confused the issue earlier. With Lender X will be very useful for commenting before the appraisal is received. Once the report is finished, just like before, you obviously know who your appraiser is and how to get a hold of them. So then, the comments can go directly through email. Now, we need to keep in mind, if we're doing the mentioned value rebuttal, this is a big deal, and that we can't just start beating up the appraiser at the branch level. We have to gather the information, go through the appraisal desk, but obviously you could use email to get a hold of Stephanie or your underwriter as well. Sorry if I confused that. Hopefully that answers the question.
Okay. Any additional questions? Oh, it does. Thank you.
Awesome.
It's the response to your last answer.
Yeah. Yeah, guys, if you have anything, please type it into the question or the chat window. We'll wait a few more minutes.
Go ahead and stop the recording.
Yep.
All right, we're going to go ahead and stop the recording. This will be available on our training channel for future replays if you want to relive the magic. And we'll leave the line open for a couple of minutes just in case there's any more questions. If you don't, we have one that just came in. Do we have a standardized appraisal reconsideration form for a value rebuttal?
No, we don't.
Okay. Can we get one?
Can we get one? We probably could.
Yeah.
Ortiz, yeah, sure. Make one.
Yep. We're going to task you with that, Mike Ortiz.
All right, recording will be stopped. I'll try it in my free time, okay. Have a great day, everybody. Stay on if you have any more questions.